Hey everybody, this is Alex Merced from Greico Financial Trading, and welcome to this video on state securities law. A very important topic for exams like the Series 63, the Series 65, the Series 66. So the best thing to do is to kind of lay the foundation and talk a little bit about the history of state securities law. So let's take a quick trip down the journey in the history of state securities law. I'll see you guys on the other side. In the late 1800s and the early 1900s, there was a plague of securities fraud in the United States. A plague of fraudsters selling securities that didn't exist, causing financial hardships for innocent people. Until 1910, when Kansas passed the first Blue Sky Law. These laws sought to limit fraud by requiring the registration of persons and securities. So if you were a company looking to sell your securities in a particular state, you would have to register those securities in that state. If you were a company that helped investors invest in securities or worked for a company that did such, you would have to register with the state. So if someone tried to sell you a security that wasn't registered or they weren't registered themselves, this would be a good sign that they may be a fraudster. Following Kansas' lead, several other states began to implement their own state securities blue sky laws. The problem was that from state to state, the rules were very different, making it difficult for companies to do national securities issues. So in 1956, the Congress passed the Uniform Securities Act to act as a blueprint for state securities law. To further eliminate the barriers to national securities issues, in 1996, the Congress passed the National Securities Market Improvement Act, which eliminated duplicate registration of securities and investment advisors. And that's the history of state securities law. Hey everybody, this is Alex Merced again, and well, that's state securities law. And what we're going to do is we're going to re-travel down that road and just kind of give you that story one more time because it's important. Everything we're going to talk about throughout this series of videos has to do with these events in history. So let's explore it a little bit more. So we're going to explore state securities law. So as we heard, it wasn't until 1910 to deal with all the fraudsters that Kansas creates the first blue sky laws in 1910. Problem is, the question was, do states have the authority to be just creating these securities laws? That answer got, well, answered in a Supreme Court case in 1917. So the Supreme Court codified the right of states to be able to create their own securities laws, which were known as blue sky laws, because the idea is that these securities that were being issued, these fraudulent securities, were pretty much had the only backing of the bright blue sky, meaning the backing of nothing. So the first blue sky laws are created in 1910. In 1917, the Supreme Court sort of codifies the right of states to be able to create these laws, and then every other state starts creating their own versions of these laws, creating 50 different versions of the same laws with different forms, different requirements, making it very burdensome for any company to issue their security to all 50 states. So Congress is like, well, we want to regulate, we want to protect the public, but at the same time, we don't want to hamper business and their ability to raise capital because that grows the economy and makes our lives better. So we wanted to simplify the process. So in 1956, they passed the Uniform Securities Act, which does just that. So in 1956, to standardize blue sky laws, Congress passes the Uniform Securities Act, the USA, which becomes the blueprint for state securities law. So each state can sort of tailor the blueprint of the Uniform Securities Act any way they want, as long as they don't contradict the federal law. Okay, as long as they don't contradict the federal law, they're good. And they can tweak that and customize that Uniform Securities Act, that blueprint for their state. Made life a lot easier, because now when I went from state to state, the paperwork was the same, the rules are the same, everything is generally the same. Problem is, I still have to do it 50 times. So I'm registering with the SEC under the Act of 33, and then again with each state. Simpler, I don't know, it's like the same paperwork with each state, but I'm still doing it 51 times, 50 states plus one SEC. So they realized that this is kind of redundant. So in 1996, they passed NISMIA, the National Securities Market Improvement Act. So to reduce the amount of duplicate registration, they passed NISMIA, which basically said that any securities or investment advisors that were already registered with the SEC are considered covered. Now, if you're a covered security or a covered advisor, then you do not have to register with the states. The states cannot require registration. But then the states complain. They're like, wait a second, we make a lot of money on charging fees on registration. So if you tell us we cannot charge fees, that's going to cut into our bottom line as a state. That's not going to fly with us. So what they do, the compromise is they tell the states is that, you know what, while you cannot charge or you cannot require registration, what you can do is you can require a filing a notification. So they're just notifying you that they're going to register or issue securities or set up an advisor in that state. And you can charge them for that filing a notification. So you can still require filing a notification. So covered securities, covered advisors cannot be required to register, but they can still be required to notify. Now, at the end of the day, who's enforcing all these rules? There's got to be someone in charge. You know what? I think we're about to find out who is in charge. So I'll see you guys in a minute. In the Uniform Securities Act, they had to name someone to be in charge of enforcing the state securities laws. So in the Uniform Securities Act, that person is named the administrator. So when dealing with federal laws, you'll be dealing with the Securities Exchange Commission. You'll always be dealing with the administrator when you're dealing with state laws. The administrator can subpoena your files and records. They can conduct public and private investigations. They can deny, suspend, or revoke the registration of any person or any security with the state. They can issue cease and desist orders without the opportunity for a prior hearing. They can petition a court for an injunction. They can require a consent to service of process. They can change any of the rules as long as it's in the public's best interest. The administrator is the king or queen of state securities law. Okay, so the administrator is the person in charge. So every state's going to set who this administrator person is. It could be different from state to state. But the way the law is written, whoever is the administrator, they enforce the laws of the Uniform Securities Act in that state. So let's examine what those powers of the administrator are. So that state securities administrator has the following powers. They have the power to suspend, expel, reject registration of any security or person. Now what they can't do is they cannot suspend or expel someone based on information on their initial application. Why? Well, the reason is, in order for me to suspend you, you have to already be registered. For me to expel you, you have to already be registered, which means I've already looked at your initial application and I already deemed it sufficient or good. So I can't retroactively like, nah, I don't like it anymore. The only thing you can do is that once you declare a registration effective, you do have 30 days to retroactively deny it, but it's still considered a denial, not a suspension, not a revocation. So be careful when they ask you what the admin can do, because while they can suspend, expel, and reject, they cannot suspend or expel based on your initial application. Okay, they have the power to conduct public and private investigations, meaning they can tell everybody that they're investigating Bob, or they can tell no one they're investigating Bob, and then surprise Bob with a fun indictment. But they have that choice. They can publish information about violations. It's kind of like being in college, when you could read the college paper and it would have the police blotter, and you could see who was drunk and disorderly the night before. Same thing here. So if someone is caught churning grandma's account, we can publish that in the local paper, so that way we know who is being bad. And we can subpoena your records. So the administrator can be like, you know what, I need your order tickets. You know what, I'd like to know who your customers are. I'd like to know what recommendations you made. Any kind of records that you're required to keep, they can subpoena and say, hey, let me look at those records. Now, they can compel testimony. So while they can force you to take the stand, they cannot force you to incriminate yourself, because that would violate your Fifth Amendment rights. So you can take the stand and then plead the Fifth and say, hey, I'm not incriminating myself. But if they grant you immunity, then that's out the window, because anything you say will not be used against you. So in that case, your Fifth Amendment rights are out the window, because you cannot be incriminated if they grant you immunity. Now, they can issue a cease and desist order without providing a hearing. Meaning, if you're doing something bad, and we're pretty sure you are, we'll send you a letter saying, stop it. And we don't have to go to a hearing before you stop it. You're supposed to stop it the minute you get that letter. Now, if you don't get that letter, or if you do get that letter and you don't listen to it, then what I'm going to do, if I'm the administrator, is file with the court. I'm going to petition the court for an injunction. And they will issue that injunction, meaning you must stop. And if you do not stop, now that you've been enjoined, meaning an injunction has been filed against you, then, well, you'll be in contempt of court, and then you're looking at jail time. So basically, first I'll send you a cease and desist letter. If you don't honor the cease and desist letter, they want to get the court involved, and the injunction will occur, and if you ignore the injunction, then you're in real trouble. Now, what else can the administrator do? They can change the rules. The only thing they cannot change is the definition of an exempt security. So they cannot change the definition of an exempt security. Why? Because that includes treasuries. And the federal government does not want to take the chance that the administrator may say, treasuries aren't exempt anymore. So they're like, nope, can't touch that. Now they can require a consent to service of process with all initial registrations. So when a security registers with the state, a person registers with the state, they will all have to include a consent to service a process, which is just basically means that they're giving the state the permission to accept subpoenas on their behalf. So that way, if you get sued, it's no secret. You got the subpoena. And you can't escape service processors to avoid being served. They can require the filing of advertising, because they want to make sure that you're not telling the public the wrong stuff and misleading them, saying, hey, buy calls when the market's going down, because then you're going to cause people to lose money, and that would be bad. So generally, regulators want to look at your advertising. They just can't require to look at your advertising of exempt securities, which again are like treasuries, munis, because governments don't want you messing with their securities. Now, if you are subject to any kind of order from the administrator, you could appeal the order. So again, you got to honor the cease and desist order up front, but you could go to a hearing to have it rescinded, as long as you apply for the hearing within 60 days. Now, when you file for your registration, whether as a person or as a security, there are several things that may trigger the fact that you may be suspended, expelled, or denied your registration. So, for example, if your registration form is incomplete or misleading, they're going to deny your application. If you violated the act, they might suspend or expel you, meaning you churned someone's account, you guaranteed someone against loss, you did some sort of violation. You're subject to an injunction, so that court has enjoined you. They have issued an injunction to tell you to stop doing business. You are subject to a felony or a financial misdemeanor in the last 10 years. Then you're not going to be in the industry. If the terms of a securities issue are unfair or unreasonable, meaning we're charging too much versus what the company's worth, we're paying the investment bankers too much relative to how much we're raising what the issuer's getting. So if anything smells bad about an investment banking deal, they can tell you, no, you're not going to be registered, and issue a stop order to your registration. So again, the term stop order just means that this registration is not going through. If you don't pay the filing fees, they're not going to process your application for free. So if you don't submit the money, they're not going to process your application. If it's insolvent in the public's best interest, so this company's out of money, and in the public's best interest, we're going to not let them do business anymore. You're unqualified, and it's in the public's best interest. So the mere fact that you're new to the industry is not reason enough to deny your registration. But if you've never worked in the industry before, and your first job is a supervisory role, then the administrator might say, you know what, that doesn't seem like it's in the public's best interest. So let's not let them be registered. Well, then that's fine. So again, because it's in the public's best interest, it has to be, context, the right choice. If they no longer exist, which means the individual who's registered has died, the company has gone out of business, or the security no longer exists. So in that case, there's no need for the registration anymore. If they failed to properly supervise, so if you're supervising people, buying, selling, recommending, etc., and they do shenanigans, and you should have caught it, but you didn't, you're going to lose your registration, and we're going to have to put somebody else in charge of supervising those people. Now, if for any reason you do get a stop order on your registration, meaning saying, hey, you can't be registered, you can appeal that order, and once you appeal that order, they have 15 days to schedule the hearing. So that way we can see if that stop order is going to be overturned. So this gives you the first foray into the history of state securities law and a little bit about what the administrator can do. I'll see you guys in the other videos in this course. Thank you guys for watching. See you guys soon.